Hello, Professor Withers. This is my final presentation of the course Intellectual Property Advising Inventors, Protecting Innovators with Patent, Trademark, and Intellectual Property. My name is Lilian Puigcamp, so let's start it. As an introduction, intellectual property constitutes a powerful strategy to foster innovation and competitiveness. In many companies, innovation and intellectual property have a close relation with a competitive advantage in top-ranked organizations by promoting innovation using intellectual property protection such as patents, license, and trademark, and informal protection methods such as secrecy, lead time, and design complexity. So in this presentation, we are focused on the formal one and the formal IP protection such as patents and trademark. And also we are going to discuss about the importance on copyright and trade secrets. Intellectual property has different types. So patents, trademark, and in general, intellectual property protection mechanisms such as copyright and trade secrets. So let's start talking about the first one, patents. According to the World Intellectual Property Organization, a patent is an exclusive right granted for an invention. Patent also benefits inventors by providing them with legal protection of their inventions. However, patent also benefits society by providing public access to technical information about this invention and thus accelerating the innovation. In addition, the United States Patent and Trademark Office classifies patents into three types. The first one is the utility patents for inventing a new or improved and useful process, machine, article of a manufacture, or composition of matters. The other one is the design patents for inventing a new, original, and ornamental design for an article of manufacture. And the last one is a plant pattern for inventing or discovering an asexually reproducing any distinct and new variety of plants. In addition, the United States Patent and Trademark Offices identify 5 main steps in the patent application and in maintenance process. For example, the first step is get ready to apply. Then this step, for example, the innovator has to be aware about the type of intellectual property it's going to need. The second step is determine if the second part of this step is determine if your inventor is available. This is part of also the first step. I mean, for example, you can apply for a patent if the can or cannot be patent. So also in this first step include the search if your invention has already been publicly disclosed or by another party, and also include what kind of patent do you need. So you have to identify first also the classification of the patent you are going to employ. How much is going to cost is another important consideration in this step. And do you need, for example, some international protection? So be aware about that matters before also go to the next step. The second step is file your application. In this step, for example, provide an outreach and education for independent inventor who file patent application without the assistant or registered patent at an open entrance. For example, here includes identify, for example, a patent center or a patent electronic business center or form for patent also application. I mean, for example, you can do it online or you can do it especially in American events, application assistant units, inventor assistant. Also, if you consider patent cooperation treaty. The third step is application prosecution. So filling a patent application on your own provide an outreach and education for independent inventor who file patents. So, okay, the fourth step is receive finally your patent. So in here, for example, states with experienced examiners who answer general questions about patent examining policies and procedures. And the other step is maintain legal protection of your patent. So once you receive the patent, you also have to be in touch with legal agencies and special lawyers. The other important aspect in the intellectual property mechanism is the trademark. According to the World Intellectual Property Organization, a trademark is a sign capable of distinguishing the goods or service of one enterprise from those of other enterprise. Trademarks are protected by intellectual property rights, of course. Some example of trademark, for example, one of the most well-known brands are, for example, Starbucks. We can see, for example, next to the logo, the letters T and M. So another example is Nike. So, and the other example is McDonald's. So we can see that this how impact and how important is trademark to be a well-known brand and being sustainable the brand identity in time. So we are going to discover a little more about the trademark and its role in brand identity and competitive advantage. So trademark signs contribute on developing a brand identity that allows companies and firms to differentiate themselves from their competitors. This legal protection allows firms to build loyalty and distinguish themselves from competitors. This differentiation is particularly relevant in some industries like fashion, electronics, technology, and consumer product sectors, in which brand management is especially important. Trademark signs contribute to developing a brand to lock the hearts of the client, and this brings loyalty and sales repetition. Okay, so some general intellectual property protection. Patent and copyright protections have different impact on the differentiated strategy, but aiding companies to ensure revenues, commercialize their innovation, prevent piracy, license and protect for copy and imitations from competitors, for example. So it's important to include this concept also with the other intellectual property mechanism and the strategy that we talked, so patent and trademark. For example, copyright, the first one, copyright or author right is a legal term used to describe the right that creators have over the literary and artistic works. Work covered by copyright range, for example, books, music, paintings, sculpture, and films. It's especially relevant for artists. To computers, programs, database, advisement, maps, and technical drawings. And trade secrets constitute more like classified and confidential information that can be sold or licensed. One particular case of a study is Tesla dispute with other big brand in the electronic vehicular industry, which is Rivian. So Tesla is always associated with a successful case of open innovation, the focus or shared knowledge approach. However, in 2020, the company filed a lawsuit against Rivian for a case of trade secret violation. Tesla claimed that Rivian encouraged its employees to disclose confidential information, including property data related to electronic vehicle battery technology. In late 2024, the case was settled out of court and dismissed. So even though Tesla it has a approach mostly focused on open innovation and this sharing knowledge approach, they have the company has problems, especially still this problem is still at this year. So because they want to continue with the battle of this case. So one question for further discussion. How does intellectual property impact the innovation ecosystem is particularly relevant for some, for example, countries and regions. What are ethical dilemmas about human and intellectual property rights regarding some specific areas such as health, education, and research? How the United States Patent and Trademark Office work with other countries, specifically in legal dispute and battles, to solve international intellectual property legislation, and what are some challenges in the U.S. state intellectual property legislation. Okay, in this slide, we are going to share some resources available for inventors. Here we can find some list of organizations, in this case, websites, legal service provided by government offices also. The slide we are sharing all the reference that we include in this presentation. And that's it. Thank you for your attention.